The court hears serious charges and bond status. The judge issues strict warnings and gives one final chance to follow legal orders. Failure could mean jail or increased bond.
Good morning. Give me just a second, sir. You are John Tat Taylor?
Yes, ma'am.
And Mr. Taylor, it's very important that you are on time to court, okay?
Yes, ma'am.
I'm going to recall the bond forfeiture. Let me find it here.
Yes, ma'am. I live out in Fort Worth, and I called and told them I was on my way, but there was traffic.
Okay, that's fine. So this is your initial appearance, Mr. Taylor, in cause number 25, DCCR 1427. You're charged with the state jail felony offense of fraudulent use or possession of credit or debit cards, and that's from July 17th of 2025. Your indictment alleges a couple of prior offenses. Since you have made bond in your case, have you had an opportunity to hire a lawyer?
No.
So what I'm going to do, Mr. Taylor, is reset your case for about 30 days or so to give you some time to try to get a lawyer hired. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what you need to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand? Step in front of the clerk and she'll give you your reset notice, please. And let's see, or is the one just on the DWI?
Yes, Your Honor.
Okay. I'll take it. And that's all right. If you'll just make sure you get that emailed.
It should be.
The attachment.
Sarah's email.
Okay. Good morning, ma'am. Are you Catherine Castillo?
Yes, ma'am.
And Mr. Pageant, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Ms. Castillo, in cause number 24, DCCR 2458, you're charged with a third-degree felony offense of driving while intoxicated, third or more, from October 10th of 2024. The indictment alleges you were previously convicted of driving while intoxicated April 11th of 2013, and then again April 22nd of 2015. And how do you plead to that charge? And are those prior convictions true?
Yes.
Did you enter your plea of guilty freely and voluntarily?
Yes.
And did you plead guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Paget?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated. You'd be on probation for 5 years. You would be ordered to pay a $500 fine and follow all of the rules and conditions of probation, and that includes that 10-day mandatory upfront time. You understand?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objections to states 1, Your Honor.
And also, it's admitted, also as a part of this agreement, the state is going to dismiss cause number 24, DCCR 2457, correct?
And there's a misdemeanor case as well.
Okay, and also the misdemeanor case.
Yes, Your Honor.
Is there any evidence that Ms. Castillo is not competent?
None, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we will come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there. Okay? We'll see you
Thank
back
you,
at
Your Honor. May I be
sentencing.
excused?
Yes, sir. Thank you.
Thank you, ladies. Thank you.
Good morning, sir. You're Dontrell Scott?
Yes, ma'am.
And this is 25 DCCR 0504. Mr. Scott's charged with official oppression, and what is the announcement?
Judge, the state and I have been discussing this in depth. I'm going to be applying for a pretrial diversion for Mr. Scott.
Okay.
And so we can get that done. I've got to get obviously some package material together for him, and then I'll be writing that letter and make an application.
So let's do maybe 45, 60-ish since we've got the holidays. If you'll get that filed quickly, I know that'll
I will, Your Honor.
take them a little bit also with the different things coming up. Mr. Scott, any issues, Mr. Smith? Mr. Scott, stay in touch with Mr. Johnson. He'll let you know when you need to be back.
Yes, ma'am.
Thank you. You're free to go. Thank you, Mr.
Good to see you,
Johnson.
Judge. Thank you.
You too. And that's for part of what I usually tell you to do. But what I am going to tell you is you probably can hold off on hiring someone. If everything goes well, you adhere to the bond conditions, she takes the class, then at some point, it looks like your case will probably be disposed of without the necessity of you hiring an attorney. It probably isn't a bad idea for you to start looking at least. And obviously, I understand that you guys, it looks like you're trying to work things out, but you're gonna have to not do that for some short amount of time.
Okay, I've been going through the issues, the illnesses and everything, and then I took in her son, 12 months old, because the father died. And I'm the provider of the house. She don't have a job, she's a full-time mother. And I'm the one that pays for all the bills, all the food, everything.
So here's the thing, it's a second-degree felony. All I know is what you're charged with is serious, and I cannot feel comfortable without more information or some type of hearing. Now, if you want to go hire a lawyer and they can file something to come in and have a hearing where everybody has notice of it, the district attorney can put on any evidence. If she wants to show up, she can. Then we'll discuss it at that point. But the only way to get that done is going to be probably to get, let me see, who's his court appointed? Who's his court appointed? I got it. Mr. Parker? Mr. Parker was appointed to represent you while you were in custody. He is still your court-appointed attorney. Talk to him about all of these issues. He can file something, we can have a hearing, have her here, and then I will consider lifting that no contact. As of now, it's a no contact. So
Pastor, he can do it, Pastor, we can,
well,
just trying to go.
nothing's going, listen. You see how many people are in here today? I have that many people every day. I understand you've got a lot of issues. I'm trying to help you out. Talk to Mr. Parker. You have a no contact as of now, period. Step in front of the clerk. She'll give you a reset notice. Good morning.
Judge, actually, I forgot there's a new case. We need to sign up for the new case as well.
Oh, okay.
I thought it was just supposed to trip over.
Okay, I don't see anything yet anyway. I'll hold them all.
Okay, I'm sorry. Judge.
Go have a seat, ma'am.
Quick reminder, if you enjoy real courtroom breakdowns with honest commentary, make sure you subscribe. We upload daily and your support helps us bring even more powerful cases to the channel.
Good morning, you're Devin Spites. Y'all can come on up. And Ms. Hawkins, will your client waive the formal reading of the indictment?
Yes, ma'am. Judge, we're going to plead to both counts of the indictment. Make this a second, please.
Thank you. Mr. Spites, in cause number 25 DCCR 0023, you're charged with a third-degree felony offense of theft of property from September 14th of 2024. The indictment alleges you were previously convicted of felon in possession of a weapon, a third-degree felony, May 18th of 2023. And how do you plead to that charge? Speak up. And is that prior conviction true? Did you enter your plea of guilty freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Hawkins?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 5-year deferred probation $500 fine, and there would be restitution that would be determined between now and when we came back for sentencing. Is that your understanding? Do you also understand that if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number one.
No objection.
It's admitted. Is there any evidence that Mr. Spites is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you are mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. All right, thank you. See y'all back at sentencing. Ms. Holmes, the motion to,
Dismiss, Your Honor.
okay. Boy, everybody's getting they're lining them up today.
You got like three coming from me today.
I see. All right, sir,
And
you're
Judge, I'll just
Elijah
put on the
Riley.
record while we're here, last time we were in court, I received a sworn statement from an eyewitness to this incident that refuted what was essentially the official narrative of what happened. Without that testimony, the state cannot prove any of the elements of this case. That's why I'm dismissing.
All right, I will sign that dismissal. Mr. Riley, I'm signing a dismissal in your case. Obviously, something went on. You need to stay away from anything and everything that's going to get you back in here, okay?
That was my house.
You're free to go. You're free to go. I need your client to sign that, please. And are we going just on the counts for the DWI, or are we going on?
Just count one. Just for the DWI, Your Honor.
Good morning, sir. Are you Dustin Drake?
Yes, ma'am.
And Mr. Lane, will your client waive the formal reading of the indictment?
Yes, Your Honor.
And Mr. Drake, the state has elected to proceed on count one only. It alleges you committed the third-degree felony offense of driving while intoxicated, third or more, from July 22nd of 2024. It alleges that you were previously convicted of driving while intoxicated February 8th of 2012, and then again January 22nd of 2021, and June 22nd of 2022. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with? And are those prior convictions all true? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lane?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And so there's no agreement, is that correct?
It's essentially a 10-year cap, Your Honor.
So the agreement is not to go
Pleading open
forward
to the third
on,
degree.
okay. So it is a plea bargain because, and there is a waiver of right to appeal because the prior offenses are waived, correct?
Correct.
And I did waiver, but we could do also plea bargain if the court wants.
No, this is fine the way it is. It shows that you did the waiver. I just want to make sure. I'm going to, just to make sure it's all clear as part of that plea bargain, if with their, well, on the unagreed page, I'm just going to write in with everyone's permission that part of the agreement was to go on just count 1 and not the prior others. That would make it a second degree. Well, his prior felonies would make it a second, so that's what the plea agreement is, to go on count 1 only.
Oh, okay.
So I just want to make sure that that's on paperwork somewhere that shows that there was an agreement for something, and that's why he waived right to appeal.
Yes, sir.
Okay.
Okay, Your Honor. Thank you.
No, it's just complete as a lesser included. It's not.
Okay, and so there's no agreement with regard to, other than the fact that they're going on count 1 only. And so in effect, that means that it is up to me to sentence you in the range of punishment for that third degree felony, which is between 2 years and 10 years, you understand? And as long as I do that, then you'll be waiving or giving up any right to appeal. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? And I want to make sure you understand you have an absolute right to have a jury come in and determine two things. The first would be to determine if you're guilty or not. And then if they find you guilty, you could leave your punishment up to them. By going forward this way, you're waiving that and leaving it up to me. And is that what you want to do? All right, state tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Drake is not competent? All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, be sure and get that information to Mr. Lane. He will present it to me on your behalf when we come back. On your way out of the courtroom today, you need to stop and talk to the probation department, and she's sitting at that desk right back there. Okay? Thank you.
Your Honor, I was
Is that
just going
mine?
Well, I was just going to ask if we could get, he has a full hip replacement Monday, and I think it's going to be about a 6-week recovery.
We're at least 6 weeks out, so if you want to do it January 26th. So,
Thank you.
okay, thank you. All right, be sure you stop and talk to probation.
Brian Battle, Jonathan, Brian Battle.
Second chances exist, but compliance is mandatory. Disobeying court orders leads straight back to custody or harsher conditions. Accountability, not excuses, decides the result.